back to mention item number 8, 27 and 30 for adjournment.
8, 10,
27 and 30.
8, 27.
Yes, Lordship.
Then
30. 30.
wait for your turn. Pass the order.
May I please, Your Lordship? I beg to mention for item number 21. Lordship, my senior's illness, so this matter may be taken after 2 weeks.
Wait for your turn, ma'am.
Okay.
Wait, please, I beg to mention item number 4 and 9, Lordship. Conducting counsel Mr. A.W. Aman is out of station. His name reflected advocate leaves note, Your Lordship.
Wait for your turn.
May I please, Your Lordship? Lordship, I beg to mention item number 23, 28 and 32, Lordship.
23.
28 and 32.
Wait for your turn.
Obvious, Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of a matter relating to, foreigners matter. It was last posted on 8 September 2023, and after that, it has not came up till now. So any date, my Lordship, may
What is the number?
WPC 5055 of 23
5055.
of, yes, 5055 of 2023.
Second May.
Second week of like Lordship.
May it please Your Lordships. Lordship, I beg to mention item number 15 as I'm appearing on behalf of Jed Hussain, Lordship. The council is out for the for today is a voting day for them. So he is out and he wanted to mention this
Okay,
item.
then
Item 15, Lordship.
only 15.
Yes, Lordship.
As the leading counsel for the petitioner, Mr. Zaid Hussain is out of state. Place this matter after 2 weeks on a date to be fixed by the legislature.
Macho.
Have any instruction to go to this case, my Lord?
Regarding registration, Lordship, so the concerned has already registered her name within time, Lordship.
Mr. A. Chaudhary, Lion Council.
Yes, Islam.
Sorry, here. Mr. F. Islam, Lion Council appearing for the petitioner on instruction, is not pressing this petition. Petition stand dismissed, being not read.
Please.
No representation on behalf of the petitioner. The petitioner is on interim protection and interim bail since 2011 purpose. The relevant record from the foreigners tribunal number 5 Kolkata that was called for on 2011. Even received is available as guest recording. Even in last occasion, 0104 the petitioner remained unrepresented. Let's go.
Here, one case record from Dhubri was called for, whether that record has come or not, my lord. Page 79. This petition was earlier declared as Indian by the tribunal at Dhubri. 32.
But
I think
Heard Mr. J. Ahmed, counsel appearing for the petitioner. And Mr. A.I. Ali standing for election for Mr. Vijay Patel. Also heard Mr. Z. Sharma and D. Sharma. Standing counsel from the Patna, some for the numbers 2, 5 and 2, 6 and 7. As well as Mr. P. Sharma, this is the number of some for the 5. This to do, returnable by 1. Petitioner is an interim protection and interim aid. Since 2005. This will not leave this jurisdiction. The point of police or the deputy commissioner of police border compartment. Right. Subject to the compliance of the order is 2005 and steps to the respondent authority. The petitioner shall be on interim protection and interim aid. granted became a date of 22 until further order. Legislative has already received the relevant records from the foreigners tribunal number foreigners tribunal number to come across Guwahati, as well as foreigners tribunal number 8, Bullock okay. That's the matter. What's your good name?
S.A. Borgoya, Your Lordships.
On for the petition. Yeah. G Sharma 3 5 P Sharma 4. Raise the postal on second.
Interim order may be continued, Lordship. Interim order,
Subject to compliance.
Lordships.
Okay. Interim petition, 2605. Foreigners tribunal above one number. Depend of place will come up. Next step.
Deeply obliged, Lordships.
May please, Your Lordship. Culture was called for my lord, I was an interim.
Affairs some. Two. Six. P Sharma. Really. 5 P Sharma. 4 interim petition. 280522. Records from foreigners tribunal number. Point of police order. Next steps, Mr. Hassan.
Yes, yes.
Copy lieutenant. Interim protection date 29/05/25. Yeah, go to the liquidator second of clip. Steps same day. तो point of place border होता है. Foreigners tribunal number 10 होता है शंकर नौगांव. Foreigners tribunal नौगांव 10.
May please, Your Lordship.
Not in this case, shares to receive my lot list. Notice may be issued. Alright. 26 D Sharma, 3 AIL, 5 P Sharma, 1 architect other, registered post court, interim protection bail 26/06/2020, Superintendent of Police Border Borpeta, Foreigners Tribunal number 4 Borpeta, shall not leave. Next steps. Gosh. Miss.
P. Ghosh.
What? 2, 6 G Sharma, 3 P Sharma, 4 AIL, 1 architect to the 5 registered post. Interim protection bail 02/09/2020. Foreigners Tribunal number 2 Dhemati, Taxila Patan. Superintendent of Police Border Dhemati. Shall not leave. Next steps.
Obliged.
I got a picture the rector put it 4/9/2020. No, no, like that. No, 1 architect to the 2 AIL, 3, 5 Z Sharma, 4 P Sharma, 6 register posted. Registry shall retain the records of the relevant records received from the Foreigners Tribunal Bongaigaon number 2 person to be ordered at 04/09/2020. In the interim, subject to the appearance of the petitioner before the Superintendent of Police Board of Bongaigaon on or before 17th May. 15th. Condition get appointed. Take steps and appear before the Superintendent of Police Board of
Lordship,
Bongaigaon.
deeply obliged, Lordship.
None appeared for the petitioner on call. The name of the councils have been reflected in. The registry shall retain the relevant records received from the industry and purposes from here. Pursuant to the order of the 15th list of. the- On a date for the case, but
Fiona, kindly pass over the matter for the time being.
doesn't matter. What's your good name?
B. Chaudhary.
B.
B. Chaudhary.
Minister will come to. will- Impugn protection order 21 10 20. Shall not leave. To the some. To an by. PP Sharma. 4 AIL. 6 is the court. 1 articulate. Shall not leave. Okay. Take steps on the respondent.
Obligation, Your Honor.
No representation on behalf of the petitioner. The relevant record from the furnace Nagaon port number 10, Daboka, Ojai. Received by the registry person to the order at 19 Just after. So it's on the
Your Lordship, my senior along with his family have gone to Nagaon to cast his vote today. Your Lordship will be pleased to list this matter on 1st May or 3rd May. Tell your colleagues.
May it please your lordships. Lordship, it's a contested matter. Order is at page 29, lordship.
Order 6, Metala Council appearing for the election. And Mr. Z. Sharma, standing counsel from Department of Assam for election number 2, 6 and 7. Also heard Mr. A.I. Ali, standing counsel elections for election number 3. And Mr. P. Sharma, petitioner senior government of Assam for election number 5. And a reference being made by the Superintendent of Police ordered. Ball. Foreigners Tribunal number 1, Balpura. In FT case number 8021 of Z of 16. After considering the evidence by her and hearing the party by its opinion dated 29/02/2023, appoint the petitioner to be foreigner under the Foreigners Act who had illegally entered into territory of India and were at Assam on or after 25/03/1971. Dissatisfied with the said opinion. Dated 29/04/2023. The petitioner filed a petition on 22 June 2024. Issue rule. Call for the records of FP case number 8021 Z of 16 from the Foreigners Tribunal number 1. Architect 231. The Sharma 267. AIL 3. P. Sharma 5. Aru. Registered person test number. Honorable Property. Second of May. Call for the records. Call for the records. Call for the petitioner shall appear before the Superintendent of Police order call for Honorable 15 of the bail penny.
Yeah,
To
okay.
appear before the Superintendent of Police order.
Yes, Lordship. Much.
The people that you say,
May I please, your lordship? Lordship, this is a contested matter, your lordship. And the opinion is at page number 29, your lordship. But before going to that, your lordship, my case rightly comes under section 2, your lordship. Subsection 1, clause B of the proviso part, your lordship. Of Indian Citizenship Act, your lordship, 1955, your lordship.
Superintendent of Police Border Norm. Finance Tribunal 8 Nogawasa. FT within bracket K case number 526 of 2017. Opinion and order is 19/11/2019. Petitioner to be a foreigner in the Foreigners Act 1946. Filed its petition on 10/04/2024. From modern foreign companies. Notice. I go to ruler silver. Returnable by 6/6. Right. You appear before the Superintendent of Police Board of
Lordship.
Nagaon on or before 15th of May.
Much obliged.
Take steps on the respondents. Yes, Mr. Hassan.
Yes, my lord. May please, your lordship. Petitioner declare foreigner post of civil on lordship. Petitioner submit the voter list of 1966, father and mother, 1970, father and mother, and 1989, father, mother, along with the petitioner, and also submit the SLC edit and mark certificate also. my lord.
Hassan for the petition. P. Sharma 2, 6. AI Ali 3. P. Sharma 5. Rule returnable by 6. Superintendent of Police Border Bangsa. Furnace Tribunal Bangsa. Case number 22 of Bangsa 202. Including final order of opinion 29/12/2023. Filed its petition on 23/04/2020. All for the records of appear before the Superintendent of Police Border Boxer on or before 15.
Published rule.
No representation on how the petitioner on to name of two counsel. List of the three names in the
May I please, your lordship? Lordship, contested case, lordship. The opinion is case number 31, your lordship. The same case, your lordship, comes under section 2, subsection 1 of the B of the proviso part, your lordship.
G. Bora for the petition. AIL 2. G. Sharma 3. AIL 2. 4. 2 and 4. 2, 4, 5. G. Sharma 3. 7. G. Sharma 6. Impugn opinion plus order 2308/2022. Tribunal number H Nagaon. FT within bracket A case number 978/2015. Superintendent of Police Boda Nagaon. Rule 6 steps by second police. Appear before the Superintendent of Police Boda on or before 15th of May.
Much obliged.
But in this case, I need some time loss. In this, in fact, I have lost my brief and also the contact with the client loss.
Heard Mr. and Quite Council appearing for the petition. And, Mr. Z. Sharma standing counsel home for response number 2 and 3. Also heard Mr. P. Sharma. Additional senior government for response number.
I am allowed to reconstruct the file loss.
Rule returnable by 6 weeks. Market April 3-1. Market 2, 3, 4. Retain the records received from the foreigner tribunal second Ramadji Sela Kota. Pursuant to the order of report dated 09. Such and such. Subject to the compliance of the order, shall not leave the jurisdiction. Superintendent of Police ordered subject to the compliance of the order dated 09/06 in Australian as well as today specified the respondent authorities shall not obtain the petitioner in custody, shall not deport him from territory of India, pursuant to the impugn opinion dated 17/1/2017 passed by Foreigners Tribunal second Ramadji Sela Kota in FT case number 174 of 2016. Mr. Upadhyay,
Lordship,
take steps on the respondents.
Lordship. Obliged, Lordship, highly obliged.
With Mr. Lordship, my senior is suffering from illness, so this matter may be taken up.
What's your good name?
B. Setia,
B. Chetia,
B. Setia,
B for
Bhagyasree Setia.
MS B. City, Learned Counsel on behalf of Mr. M. Mohammed, Learned Counsel. G. Sharma 2 and 4, 245, P. Sharma 3. Notice in this case was issued on 28/07/2017. Issue rule returnable by 6 square. This is a letter in the record. 11 record was called from public finance tribunal by order of the 28/07. Steps honorable second. Subject to the compliance of the interim protection. And April 28/07. The petitioner shall not leave the jurisdiction of the police order. Take steps on the respondents. Honorable.
Obliged.
Notice in this case was issued on 26/07/2017. Issued interim protection, interim bail, 26/07/2017. Shall not leave the jurisdiction of the Printer Police Board or conditional. Record received from Foreigners Tribunal, Bongaigaon number 2, February.
But with the Lordship, kindly this matter is taken up after 2 weeks, Lordship.
Ms. S. Das for the petitioner. Two, 3, 5. P. Sharma 4. Notice in this case was issued on 28/07/2017. So ruled. Reports received from Foreigners Tribunal, Bongaigaon number 20. Person paid. Order dated 28/07. Interim protection, interim bail, dated 28/07. Shall not leave the jurisdiction of the Printer Police Board. Subject to the. Take steps on the respondents.
Obliged, Lordship.
May have legal Lord.
G. Sharma 2 and 4, P. Sharma 3. Notice in this case was issued on 07/08/2017. Rule returnable by 6 hours. or receive some foreigners in command on the Unfortunately, order it is 07 interim protection in pay 07 shall not leave the jurisdiction to prevent the water. Take steps, Mr. Sun.
Yes, sir. Obliged.
Notice in this case was issued on 09/08/2017. Record session from Furnace Tribunal number 4, Northbury, interim correction, interim 9/8/2017. Shall not leave the jurisdiction. Furnace Tribunal number 4, please. But let me let. Please. Asalom.
Yes.
Heard Mr. Asalom also appearing for the and Mr. G. Sharma. Running control room for 2, 3, 4. P. Sharma 5. He Vibhu on behalf of the right? HP. Yeah, for the rest. Noticing this case was issued on 09/08. Record received from Furnace Tribunal 8/3. Interim protection, interim bail 09/08/2007. Shall not leave the jurisdiction of Superintendent of Police Court. Take steps on the respondents. My left. Mr. Alam. 27. RMS. P. Last. Council for. Z. Sharma 2. B. Sharma 3. Notice in this case was issued on 09/08/2066. Borua. Record received from Finance Tribunal Nagaon. Seventh, Lanka. Borua. So, how you captain settle in dito? Direct. Any idea whether the person is still in detention? I don't think so because after
No, Lordship.
COVID, it shall not lead to the jurisdiction of point of border to the condition. Take steps on the respondents.
Obliged.
Retain the records received from the foreign experiment. Telling the trouble over there. Mari,
May I please, your Lordship? Kindly, if this matter may be taken up after 2 weeks, Lordship.
Shiva Madam. Notice in this case was issued on I need both of this. Furnace Tribunal Court call for. তুমি ব্যাপার ফাইল করিয়ে মানে Furnace Tribunal Court call for. Shall not leave. Two are four, G Sharma. Three, P Sharma. Architecture. Take steps on the respondent.
Lordship. Obliged, Lordship.
Rule. Notice in this case was still on 25. Six. Two, three, Z Sharma. Four, P Sharma. On architecture. Notice on 25 July 2007. Already in protection interim jail. When the police order. Corporate I left. Sorry, when the police order. Finance Tribunal corporate 11. Corpo. Not to leave. P Sharma to four, P Sharma. Architecture 1. Notice on 28/08/2007. Interim provision. 28/08/2007. Not to leave. Finance Tribunal Ohio number 2. Available. Take steps on the respondent. Furnace number terminal, Bongaigaon, number 2. It's in the case of 2028, 57. Frame protection and frame grade 28/08/2000. Shall not late. Metropolis border Bongaigaon. G. Sharma 2. District petition. However, the petitioner being agreed with the order / opinion dated 12/07/17 passed by the Furnace Tribunal. Bongaigaon number 2. Declaring not to be foreigner as the foreigner 19. But illegally entered into some honor from the specified honor of the that the restaurant number 3, member of Ernest Party, impugn order dated such and such after necessary particular. For the say respondent number 3 deleted. Respondent number 4 and 5 now the number respondent 3. Registration according to 32 G. Sharma 2 and 3 4 P. Sharma honor after the notice Furnace Terminal number 2 when the place shall not he does. For an tribunal program. Two, 4, 5 Z7 3 P. Sharma 1 architect. Notice issued on 30/08. For an table Morgan number 2 shall not leave. Step 2. Take steps.
Obliged lordship.
Mr.
Yes, I Talukar.
Two, 3 4 P. Sharma 1 architect. 30/08/2017. Furnace Tribunal number 2 Balparam. The Pentapolis voter shall not leave. Right. Take steps on the respondents.
I love it.
Notice in this case was around 30/08/2007. 6 weeks. Furnace Tribunal You know, Vendor Police Border Children Interim Protection Interim 33 shall not be. Location difficult from 6 to 7. Very important. Ordnance Tribunal number 1. Improve not. Look. Two, 4, is a distribution, one. Two, 4, G Sharma. 3, Sharma. 5, big. Notation this paper 89 2007. Superintendent of Police. Border Borpeta. Ordnance Tribunal number 8. Borpeta. Interim protection. 89 2007. Shall not be. Take steps on the. Mr. Barbara will finish the next item. Can will take.
Please, madam. Lords, in this case, the records of the FT case are missing. They were misplaced when the writ petition proceedings were undergoing before this honorable court. Now, my lords, today we are faced with a very peculiar situation. I am the detainee, my lords. I went and filed a petition before the learned tribunal after the order of this honorable court in the writ appeal. The tribunal, my lords, informed me that we do not have any records. How are we supposed to proceed against it? So in those circumstances, my lords, I filed this IA before this honorable court, seeking for a modification that if need be, my lords, if the state deems it appropriate, de novo proceedings should be instituted. And these proceedings which were undergoing, 344 of 2006, they ought to be declared as abated minutes, because it is not possible for me to also continue with these proceedings or become a part of these proceedings because I do not have the notice, Lordships. So today the situation is, even if I apply for a certified copy of the notice, the tribunal is handicapped to provide me that notice. That is my case. My grievances, Lordships, are at para 11, page 11 of my application. They start from there, of my IA 3444.
All for the records of WPC number 295. 2009. Disposed of one. Zero 0702. Placed on 6th.
6th of May, Milord. Any other date, Milord. 6th of May, I'll be indisposed. Milord. Any day, 7th or 8th, Milord.
10th.
10th. Grateful.
First of all, my lord, my sincere apology for having missed the matter on two occasions, my lord.
Yes, Mr. Singh, please.
My lord, this writ appeal against the interim judgment and order dated 8/11/2023, my lord. The interim judgment starts at page 261. May I read it from page 262, my lord? The learned single judge has allowed the writ petition allowing, directing that the damages which was recovered from the petitioner has to be refunded with 9% interest, my lord. May I read it from paragraph 2, my lord?
Paragraph
2, my lord, at page 262 of the judgment, my lord.
Yes, please.
The writ petitioner herein is a private limited company and is engaged in transportation business. The Food Corporation of India has issued a notice inviting tender dated 11/6/2021 inter alia for awarding the contract of the handling and transportation contract ex railway siding Salchapara to FSD Badarpur Ghat via weighbridge, including the handling at FSD Badarpur Ghat. The petitioner had participated in the competitive bidding process and had emerged as the successful bidder. Consequently, by issuing the order dated 8/11/2021, the petitioner was appointed as handling and transport contractor ex railway siding Salchapara to FSD Badarpur Ghat at the rates quoted in the tender document. As per the terms and conditions for appointment, the contract would come to an end on 20/11/2023. Although the petitioner company was awarded the transportation contract at railway siding Salchapara to FSD Badarpur Ghat. Yet the work of handling was awarded only at the Badarpur FSD, meaning thereby that unloading of bags of food grains from the loaded trucks and stacking the foods inside the food storage depot only at Badarpur FSD was included within the scope of the contract. However, insofar as the handling of food grains at the railway siding at Salchapara is concerned, the same was awarded to another handling contractor, Messrs. Anup Trade and Transport. It is pleaded case of the petitioner that as and when allotments of consignment was made to the petitioner at Badarpur railway siding, it had executed the transportation work as well as the work of handling at the FSD Badarpur Ghat without any default. Notwithstanding the same, the demurrage has been deducted from the running bills of the petitioner, which is apparent from the sanction order issued by the manager account. According to writ petitioner, there is no clause of the contract permitting the authorities to deduct demurrage from the running bills of the petitioner, since the petitioner company was not the handling contract at X railway siding at Salchapara. It has been alleged in the writ petition that the delay in unloading of wagons took place not on account of any default on the part of the writ petitioner, but on account of the negligence on the part of the FCI officials to open the wagon racks within the free time notified by the railway authorities, and therefore the writ petitioner cannot be held liable for demurrage in any, if any, charged by the railway authorities upon the FCI. The respondent have contested the petitioner case by contending that as per the terms and conditions of the contract, the petitioner is liable to pay demurrage due to delay in loading the trucks beyond the free time notified by the ANF railway authorities. It has been contended that the officers of the FCI have always received the wagons on time, even if it is in odd hours, late in the evening, and therefore the allegation made in the writ petition are wholly unfounded. It is apparent from the documents annexed to the writ petition that the railway authorities had notified free time for unloading the wagons. Any unloading taking place beyond free time would invite demurrage levied at the rate of rupees 150 per 8-wheel wagon per hour, or the part of an hour for detention of wagons in excess of the permissible free time for loading or unloading. It is admitted position of the fact that the petitioner is not the handling contract at the railway siding, in as much as Anup Trade and Transport Private Limited was the contractor appointed for handling at the railway siding. As such, it is evident that there was no responsibility on the petitioner to unload the railway wagon. Notwithstanding the same, the FCI has started levying damages from the running bills of the petitioner on the ground that there was delay in unloading of the wagons due to supply of the vehicles by the petitioner. In order to appreciate the nature of the dispute raised in the writ petition, it would be apposite to quote the statements made in paragraph 19 of the writ petition, which are abstracted here below. That the petitioner begs to state that the rake placement time is generally at the night at about 8 p.m. to 10 p.m. and the FCI officers are not present at the railway head to take the charge of the rakes in the night. The rakes are opened on the next day at about 8 a.m. to 10 a.m. for which demurrage charges are levied upon the petitioner without any default. It is pertinent to mention herein that on Sundays, the FSD godowns are kept closed and the petitioner requests to open the FSD to facilitate unloading of food grains falls into the deep year. Therefore, the loaded trucks arriving at the FSD on Saturday are received by the FSD official on next Monday, incurring huge damages. The reply of the respondent to said paragraph is available in paragraph 31 of the counter affidavit, which is extracted herein below. That the statements made in paragraph 19 of the writ petition are not correct and as such vehemently denied by me. It is specifically denied that the FCI officers are not present at the railhead to take over charge of the rakes in night. In this connection, the deponent claim leave to pay the petitioner be put to strict proof of the same. In this regard, I say that the FCI officers also worked on Sunday for doing needful for unloading of wagons if the occasion arises. I further say that the divisional manager on delegation of power by general manager levy damages charges as applicable in the lines of the appropriate terms and conditions of the tender agreement. Paragraph 8. From the above, it would be apparent that the allegation of negligence on the part of the petitioner company in its failure to place the trucks within the free time is a heavily disputed question of fact. So, my lord, the learned single judge has admitted that it's a highly disputed question of fact raised by the petitioner. Be that as it may, the other relevant question that would also arise for consideration of this court in present proceeding was to whether the terms and conditions of the contract is at all permissible for the FCI authorities to levy damages upon the petitioner unilaterally. My lord, having deciding the matter, the learned single judge heavily relied on the Supreme Court judgment rendered in the FCI versus Abhijit Paul, my lord. I will distinguish that Supreme Court decision is not applicable in our case, my lord. Paragraph 9, my lord. By referring to the decision of the Supreme Court rendered in the case of Food Corporation of India and others, Abhijit Paul, learned senior counsel for the petitioner has argued that the issue raised in the present writ petition is squarely covered by the aforesaid decision of the Supreme Court, which has affirmed the judgments of the learned single judge as well as the division bench of the High Court of Judicature of Tripura rejecting the similar claims of the FCI authorities relying upon the same conditions of the contract agreement. Mr. Borbora has argued that the manager accounts does not have the jurisdiction or authority under the law to make unilateral deduction of damages from the running bills of the petitioner company, particularly since the petitioner was not the handling contract at the railway siding and hence did not have any direct role to play in unloading of wagons. Refuting the above contentions, the learned counsel of the FCI authority has submitted that the terms and conditions of the present contract are not the same as those involved in the Abhijit Paul case, and therefore the decision of the Supreme Court in the aforesaid case is distinguishable on the facts containing that the contract agreement permits leaving or demurrages for the default of the contractor, and by arguing that if the FCI is prevented from enforcing the said clause on account of failure of the handling and transport contractor to unload the vehicle within the free time, then it would be wholly unviable for the corporation to execute the transport contracts. Mr. Singh has prayed for dismissal of the writ petition. Para 12, my lord. As it is apparent from the facts noted, the core issue involved in this proceeding is pertaining to the question as to whether the FCI has empowered under the contract agreement to levy demurrage and deduct such amount from the bills of the petitioner. The same issue had arisen for consideration in the writ petition filed by the FCI contractor, namely Abhijit Paul, before the Tripura High Court, which was numbered as so-and-so. By the judgment and order dated Tripura High Court, so-and-so, it has been held that levy or damage of the FCI on the petitioner was bad, and the same was set aside by the holding that the contractor could be held liable for such damage if it can be sustained that for negligence or dereliction of the contract, the respondents had suffered loss in course of the transportation. But for that purpose, there has to be an inquiry whether the petitioner must have his say. The learned single judge has held that the quantum of damage is to be determined by the following the due process of law and satisfying the requirements of the principle of natural justice or by the way of conciliation. It is only that even that the petitioner can be asked to make good and the loss and not otherwise. Therefore, said order was passed taking note of the decision of render in the case of Bulbul Enterprise versus Food Corporation of India, wherein it was held that the deduction made by the FCI from the bills of the contractor as damage was dehorsed the terms and contract and hence not sustainable in law. Be it mentioned herein that both the cases, the contract agreement contained the provision of levy or damages warfare upon the contract if the corporation suffers or incurs any loss due to the negligence of the contract. My lord, this is factually not correct. That contract doesn't contain the word damages, which came before the Honorable Supreme Court, my lord. The decision of the learned single judge of the High Court of Tripura in the case of Abhijit Paul, the order of the division bench rejecting the appeal preferred by the FCI against the order of the learned single judge and the same other proceedings connected with the same issue came up for consideration before the Honorable Supreme Court in case of FCI versus Abhijit Paul. After considering the terms and conditions of the contract agreement, the Honorable Supreme Court inter alia has held that since the contractor was not entrusted with the task of loading and unloading of food grains from the railway wagons under the contract agreement, hence the expression charge would not include any liability upon the contractor on account of damages. Consequently, it has held that the corporation cannot impose and collect damages from the contractor. It is thus apparent that unless the loading and unloading of food grains from the railway wagons falls within the scope of the contractor duties under the contract, damages as a penalty for non-performance of the contractual duties would ordinarily not be applicable. The matter would, however, be different if the breach of contract on the part of the contractor is established through an adjudicatory mechanism. This adjudicatory mechanism we are having in the name of GRC, Grievance Redressal Committee, which has been set up by the FCI for the contractors for ventilating the grievance of the contractor. So, my lord, the The learned single judge heavily relied on the Supreme Court judgment, and from page 273, I'm skipping the other paragraph, my lord. My lord may kindly come to page 273. Paragraph 21, my lord.
Paragraph
21, my lord, at page 273. From a careful analysis of the decision of the Supreme Court referred to above, read in the context of the section 73 and 74 of the Indian Contract Act, it is clear that unless the contract agreement itself specifies an agreed amount of damage which can be levied on the contractor for having breached the conditions of the contract, any amount claimed by the employer would not automatically translate into the debt, but would merely remain a claim if the claim is legitimately disputed by the contractor. Being one of the parties or to the contract agreement, the same would give a rise to the dispute, which would be adjudicated upon by the court or through any other adjudicating mechanism established under the law. In the present case, as noted above, there is no liquidated damage. Moreover, the petitioner was not interested with the work of unloading of the food grains at railway siding. As such, in view of the denial on the part of the petitioner of any laches and negligence on his part, which can as be the breach of the terms and conditions of the contract, the FCI cannot unilaterally recover any amount from the contractor as damages unless the liability of the contractor is determined through a process established by the law. For the reasons stated herein above, the court is of the opinion that this petition must succeed and the same is hereby allowed. Consequently, all deduction made from the previous running bills of the petitioner on account of damage are hereby set aside. The respondents are directed to refund the amounts so deducted from the running bills of the petitioners as damage within 60 days from the date of receipt of the certified copy of this order, and also to refrain from deducting any further amount of damage from the bills of the writ petitioner. It is made clear that if the deducted amount is not refunded within 60 days from the date of this order, the interest at the rate of 9% per annum on account of amount calculated from the date of this order till refund of the same shall be made payable to the petitioner by the respondent. This order would not preclude the respondent from initiating any action against the writ petitioner for realization of damage and compensation, if any, in accordance with law and in the light of the observations made herein above.
There is illegality.
My lord, I will now come to the Supreme Court judgment, my lord. I will just read out the relevant paragraphs, then I will make my submission.
Just clarify one thing. The learned single judge after going through in details, found that there was no such clause regarding the unloading of food grains at railway station.
My lord, the learned single judge has taken aid of the learned Honorable Supreme Court judgment, where
No, there has to be certain clause, right, in the agreement.
yes, that clause is there for imposing damages because of the unworkmanlike performance from the
How you have
contractor.
engaged this petitioner, writ petitioner?
Petitioner was engaged for
Where is that contract?
yes, my lord. My lord, it starts from 140. My lord, it starts from page 144, annexure D, my lord. The contract. The model tender form itself is the agreement, my lord. I will take to the relevant paragraph, relevant clause. Is at page 157.
Just
That has been also quoted in the my lord judgment also, my lord. At page 269. This liability of the contractor for losses, etc., suffered by the corporation, my lord. That is clause 10 of the agreement, Roman 10. May I read, my lord? Clause 10.
Just a minute, just. Yes. Yes, Mr. Singh.
Yes, my lord. Clause 10A, the contractor shall be liable for all costs, damages, warfare, warfage, forfeiture of wagon, registration fees, charges, and expenses suffered or incurred by the corporation due to the contractor's negligence and unworkmanlike performance of any services under this contract or breach of any terms thereof, or his failure to carry out the work with a view to avoid incurrence of damages, etc. Under this contract or breach of any terms thereof, of his failure to carry out the work with a view to avoid incurrence of damage, etc., and for all damages or losses.
Which page? 157, right. Yes, yes, we got it.
Or my lord may come to page 269. It has been quoted in the judgment, my lord. That will be more convenient. 269, my lord.
Yes.
Liability of the contractor for losses, etc., suffered by the corporation. The contractor shall be liable for all costs, damages, warfare, forfeiture of wagon, registration fees, charges, and expenses suffered or incurred by the corporation due to contractor's negligence and unworkmanlike performance of any services under this contract, or breach of any terms thereof, or his failure to carry out the work with a view to avoid incurrence of damage, etc. under this contract, or breach of any terms thereof, or his failure to carry out the work with a view to avoid incurrence of damage, etc. And for all the damages or losses occasioned in the corporation due to any act, whether negligent or otherwise, of the contractor themselves or his employees. The decision of the general manager regarding the such failure of the contractor and their liability for the losses, etc., suffered by the corporation, and the quantification of such losses shall be final and binding on the contractor. My lord, the contractor is bound by this agreement, my lord, because the agreement has been executed mutually, my lord. Now, my lord, I will take your lawsuit to the Supreme Court judgment. It starts from page 237.
Yes.
My lord, may kindly come to page 246, the analysis.
Yes.
My lord, heading is analysis. So Supreme Court has analyzed and distinguished the word charges doesn't include the word damages.
You're at page?
I am at page 246, my lord. Start from paragraph 16.
Yes.
The core question arising for our consideration is whether the contractual clause enabling the corporation to recover charges includes the recovery of damages. It is pertinent to extract the relevant clauses of the road transport contract, that is work order, the clauses detailing the description of the work liability of the contractors and the power to recover losses, which are identical in 3 appeals before us, read as under. My lord, that contract, in that contract, the MT of the agreement doesn't contain the word damages, and in that contract, the FCI has recovered the damages. So that's why the contention of the writ petitioner in that case was the charges doesn't include damages, so they cannot recover damages, my lord. So the Supreme Court has, Honorable Supreme Court has analyzes this thing and distinguished whether the charges, given the finding that whether the charges will include damages in absence of the word damages in the clause, my lord. So, my lord, this clause, brief description of what? Transportation of food grains from the depots, mandis, rail heads of Churai Bari to various destinations as per Appendix 1. And this is important, my lord. The liability of the contractor for losses suffered by the corporation. The contractor shall be liable for all costs, damages, registration fees, charges, and expenses suffered or incurred by the corporation. My lord, here the word damages is missing, my lord. Then paragraph, next page, paragraph 17. The relevant clause has been copied.
Yes.
Then paragraph 17, my lord. The corporation seeks to recover damages as a part of the charges provided under clause 12A as extracted herein above. The expression charges stand alone is not amenable to precise meaning. Its dictionary meaning is open textual, defining charges as any consideration that one must pay for the goods and services provided. Therefore, the scope of the expression charges must be understood as intended by the parties to the contract. The process of interpretation, though the exclusive domain of the court, inheres the duty of the decipher the meaning attributed to the contractual terms by the parties to the contract. It is with this purpose that we shall now proceed to understand the meaning of the expression charges. Then in next few paragraphs, some decision has been quoted, my lord. We may skip it and may come straightway to paragraph 22 at page 250, my lord.
Yes.
Keeping in mind the above referred principles, we have to examine the expression charges in the context of its related words in the contract, which are cost, damages, registration fees, and expenses. This expression indicate the different heads under which losses are recoverable from the contractors for acts of negligence, unworkmanlike performance of any service, breach of terms, and failure to carry out the work in the context of the working of the contract. This expression are equally wide and do not aid us in understanding the meaning of the expression charges. Under these circumstances, we have to understand the meaning of the expression charges in the larger context of the contract. So, my lord, to come into the finding whether the charges include damages, it has not given the aid to the Honorable Supreme Court. So,
But just read the clause, para 23.
23, yes, ma'am. I will read all the paragraph, relevant paragraph. The preamble of the contract, that is work order, reads that the contractor is engaged for transportation of food grains from the depots, mandis, railheads, and charubari to various destinations as a further clause 13 of the work order detailing the responsibility of the contractor to the extent relevant for our purpose read as under responsibility of the contractor. The contractor shall be responsible to supply adequate and sufficient number of trucks for transportation of food grains and carrying out any other services under the contract in accordance with the instructions issued by the general manager or any officer acting in this behalf. The contractor shall be responsible for the safety of the goods from time to time they are loaded with their truck. They have been unloaded from the trucks at godowns or at the destination as specified in the contract or as directed by the general manager, area manager, or any other officer acting on his behalf. We have scanned the entire contract in addition to scrutinizing the provision extracted above and seen that there is no contractual provision requiring the contractor to undertake the task of loading and unloading of the food grains from the railway wagons. This is confirmed by the written submission on behalf of the corporation where the imposition of damages is justified only for the reason that the contractor did not provide adequate number of trucks near the railway siding.
Come to para 28.
28, my lord. Applying the above principles to the present case, we will juxtapose the present contracts with similar but not identical contracts entered into by the corporation to confirm our interpretation that the word charges in the contract is exclusive and liability for the damages. Pursuantly, we will examine the certain contracts entered into the corporation by the corporation with the transportation. For example, we will refer to the contract entered into by the corporation in 2010, which is prior to the time to the present contract. brief description of work, loading, unloading food grain bags, bags from into railway wagon, trucks, etc., taking or transporting of food grains railway station to the corporation. Liability of the contractors for the losses, etc., suffered by the corporation. The contractor shall be liable for all costs, damages, warfare, forfeiture of wagon, registration fees, charges, and expenses due to their failure to carry out the work with a view to avoid the incurrence of the damages. The corporation shall be at the liberty to reimburse the themselves of any damages, losses, charges, costs, or expenses suffered or incurred by them due to the contractor negligence and unworkmanlike performance of the service under the contract of the breach of the contract. We have then it is evident from the above the contract delegating the responsibility of loading and unloading of the food grains from railway wagon as an integral part of the contract include a clear and distinctive clause for the imposition of the liability inter alia on the account of damages. Evidently, the liability clause in this contract term the handling and transport contract is starkly distinct from the present road transport contracts. We have every reason to believe that the corporation statutorily obligated to procure and distribute food grains across the nation enters into the contracts depending on the services it requires. These contracts naturally vary depending on the needs and the purposes of the corporation. With the aid of the provisions in the handling and transport contract from 2010, we are able to understand the intention of the parties while entering into the present road transport contract. As the present contract do not involve the task of loading and unloading of the food grains from the railway wagons as a part of the contract responsibility, there is no clause enabling the recovery of damages from them by the corporation. Thus, our interpretation that the expression charges is as exclusive of liability for damages stand confirmed. So, my lord, my humble submission, the Honorable Supreme Court has taken aid of different contract, different agreement to come to the finding that the word charges
Cannot be included damages. Okay.
does not include damages. My humble submission is that, my lord, the Supreme Court has taken aid of some different agreement, my lord. So it cannot be held as a ratio or decidendi, my lord. It's an obiter dicta, my lord. It is not applicable in our case, my lord.
Why?
Because, my lord, the Honorable Supreme Court has only taken aid of some different contract and come to the finding that the charges doesn't include the doesn't include damages, because the damages word was not there in the contract in question. But herein the word specifically damages is here, my lord. And we have, because of failure to provide the trucks, we have given number of notices, and we have also documented which was before this honorable.
The matters which are before the apex court, those contracts doesn't contain the word damages.
Yes, my lord.
Only the charges.
Only charges was there.
And after considering the various contracts, the relevant period, prior to the relevant period, after the relevant period, the court come to the conclusion that the word damages will not be included in the charges, right? Now, why you are saying that it is different in the present case?
Because in the present case, the word damages is there, my lord.
But the
Specific to
finding of the court is that the particular petitioner was
not interested with the loading and unloading. No, was not interested. But even then, because of the failure to provide the truck in time, the loading and unloading cannot take place, my lord. Because the materials, food grains has to be unloaded from the wagons and it has to be put into the trucks.
The trucks were not provided with,
Trucks should not be provided with.
because the petitioner was not entrusted with the work of loading and unloading. So how you can say that?
Now, my humble submission is that
Learned Singles just came to the finding that this particular authority, the petitioner, was not entrusted with the loading and unloading from the railway wagons.
that was not, he was not interested with the loading, and that's why Honorable Learned Single Judge has said that he is not responsible for the damages, my lord.
Where is your finding that the petitioner did not provide with the logistics, that is the trucks? Where is that finding?
That finding has been, my humble submission has not been taken into
Have you placed
consideration.
it?
But my this thing is there, pleadings are there, my lord. In my affidavit, and then the Learned Single Judge also held that it's a highly disputable.
No, disputed because of a different reason, not with regard to the negligence you are talking about. That part is disputed.
No,
Remaining part the court have considered.
My lord,
Court have said the entire matters are not a question of disputed. Disputed because there is negligence on the part of the petitioner. That
Yes,
part
my
is disputed, they have said.
Yes.
Where is the issue regarding the non-supply of the vehicle the matters could not be unloaded from the railway wagon. Is that an issue?
That stand we have taken in our counter affidavit, my lord. We have also provided the annexure A, the entire demurrage charges
Which
liability which has been,
Notice you have, in which show cause notice you have provided that?
my
Where
lord.
you have mentioned, in which show cause notice?
My lord, page 143, my lord may come. There are few has been annexed, that is. And their own pleading also, I will take your lordship, their own pleading, they have not been able to provide the trucks in time because of some issues, my lord. My lord may come first page at page 143, my lord. May I read it, my lord?
One
143, my lord.
Hmm.
Notice.
Hmm.
It is regretted to inform that in spite of continuous persuasion against the intent of 14 wagons of rake Act so and so placed on 2/2/2022, you have failed to supply adequate number of trucks even after the lapse of 32 hours, my lord. 6 hours are given free time to unload it. As on when the trucks are not placed, how the handling contractor will unload the wagon, my lord? The handling contractor cannot put the food grains in the platform. Otherwise, then wharfage will come into play, my lord. There is also wharfage, my lord. Wharfage means using the platform. This is one notice, my lord. I will take the pleadings of the petitioner, my lord. My lord may kindly bear with me at page 214, my lord. 214, my lord. It's an additional affidavit in reply filed by the petitioner against our counter affidavit, my lord. Page 214, middle part.
Just a minute.
Yes, ma'am.
Yes, what you want to show?
My lord, order notices are at page 186, 187, 188, my lord. 187 is sir. The order notices. 187 and 188.
The petitioner was entrusted with the handling and the transport contract, right?
Was handling at the Badarpur Ghat, where from the food grain has to be collected from the railway siding. Railway siding, Salchapara to Badarpur Ghat. Petitioner was a handling contractor at the depot, my lord, FSD depot at Badarpur, at Badarpur Ghat destination. And he was a transport contractor to carry food grains from Salchapara railway station, that is railway siding.
From Salsapara to your
My
Godown
depot,
at
my depot at
Badarpur
Badarpur Ghat. My lord, at page 214, my lord, just 2 lines.
What do you want to do?
My lord, 214, 11 line from below, my lord.
Hmm.
It starts from, it was further stated that although due to statutory RTO documents problems of the trucks supplied by the Salchapara Truck Owner Association, there was a delay in supply of trucks. However, the deponent was in constant contact with the continuously requesting the association for resolving of the issue so that immediate supply of trucks could be resumed. My lord, there was a problem with the petitioner to supply the truck in time, my lord. They have admitted. Again, on the next page, there was some labor problem with him in the Badarpur Ghat where he was a handling contractor, my lord, at paragraph 4, page 215, my lord. The statements made in paragraph in the aforesaid paragraph 15 that by notice dated section 6 2022, the petitioner was intimated that labor strike has become a regular practice at FSD Badarpur Ghat and that the trucks are being stranded for want of unloading and no work is stranded, and that the similar incident has happened on 14/6/2022 and no receipt issue operation was carried out. The petitioner has denied it. Such strikes or laborers are engaged in the entire area for one day was absolutely beyond the control of the read petitioner, though admitted, my lord. So, my lord, a similar situation arose before the Tripura High Court also, where we have moved a writ appeal, my lord. Similarly situated, my lord. Recently, it was moved, my lord. We have distinguished the Supreme Court judgment, Honorable Apex Court judgment with the present situation, my lord. If my lord may, the Honorable High Court
Now,
of
against
Tripura.
this particular paragraph, what is the decision affidavit in opposition by the railway?
No,
Right?
affidavit in opposition, my affidavit in opposition, FCI affidavit in opposition.
FCI affidavit. Against this, whether petitioner file any reply?
No, this is their reply, my lord. They are admitting. This is affidavit in reply against our affidavit in opposition, my lord.
No. Here you want to say that they have admitted the fact.
Yes, my lord. They have a problem with providing the trucks in time, my lord, and because
And
of
also
their
the labor.
untimely, the damages has occurred. Not only damages occurred by the petitioner, but the other contractors at Badarpur Ghat, my lord, at the railway siding. They have not come, only petitioner has come.
Despite having been assured by the association for early solution, the deponent made alternative arrangement for smooth operation till the matter is resolved and normalcy return at the earliest. Thus, the deponent never failed to place the advance in the requisite number of trucks at any point of time, understanding the contract of in which. So, against this, what you have to say?
Yes, my lord. That we have denied, my lord, in our further. My lord, at page 235, my rejoinder affidavit to their additional affidavit in reply.
Yes.
Paragraph 6. The statements made in paragraph 3 of the additional affidavit in reply are not wholly correct. Page 235, my lord. I specifically deny the claim of the petitioner that the petitioner never failed to place in advance the requisite number of trucks at the point of time while undertaking the contract work in question. In this regard, I reiterate and reaffirm the statements made in paragraph 13 of my affidavit in opposition.
Just see the notice, when you have given the notice. When was the time and the date and when you have given the notice?
My lord, that page 142. 142 and 143. I will read the 143, my lord. 142. Legible. May I read it, ma'am? Page 1. It is regretted to inform that in spite of continuous persuasion against the intent of 14 wagons of reg placed on 2/2/2022, we have failed to supply the adequate number of trucks even after a lapse of 32 hours. As on date, around 360 MT is yet to be transported at Salchapara to FSD Badarpur Ghat for release of the reg, lending to the detention of the entire reg. As you may be aware, the panel damages of to the tune of six times is imposed at RS Salchapara since January till March by railway authorities, mainly due to the slow pace of release of the regs. However, it is reprehensible that it has become a regular practice for non-supply of the adequate number of trucks against the inland place for which the FCI regs undergo necessary detention, leading to incurrence of heavy demurrage charges, as well as criticism from the railway authorities, which is not at all acceptable. Further, due to the short supply of the trucks of the stock position of FSD Badarpur Ghat has been depleted, and on date capacity utilization is only 77%, which would affect the issue of the PDS PMGKAY requirement of Karimganj district. Regular failure in supply of the adequate number of trucks by RTC at Salchapara to FSD Badarpur Ghat is noticed. If same situation persists, then it will be difficult to even run the PDS chain and maintain the buffer stock to meet the unforeseen situation. Your lackadaisical approach has put the FCI in deep trouble in respect of supplying the food grains under various government schemes and also maintaining buffer stock in the district. It is therefore directed to supply the requisite number of trucks immediately to release the standard reg so as to avoid further detention of the regs. Failing this necessary action, penalty as per the MPF annexes clause 1, clause 10A and 10C, 11C will be imposed. My lord, in a similar case at the Tripura High Court, the learned single judge has allowed the petitioner's case situated similarly, my lord, basing its
Where is
judgment.
the demurrage in the contract?
My lord, clause 10C, I will take your lordship at page 157, my lord.
10C.
Yes, my lord. Page 1, it is at page 157. Liability of the contractor for losses, etc., suffered by the corporation. Railway imposes demurrages on FCI, my lord, and thereafter we distribute as per the liability, my lord, amongst the contractors.
Read it.
Yes, my lord.
Ten B.
10B, the corporation shall be at the liberty to reimburse themselves of any damages, losses, charges, costs, or expenses suffered or incurred by it due to contractor negligence and unworkmanlike performance of services under the contract or breach of any term thereof. The total sum claimed shall be deducted from any sum then due or which at any time thereafter may become due to the contractor under this or any other contract with the corporation. In the event of the sum which may be due from the corporation, as aforesaid being insufficient, the balance of the total sum claimed and recoverable from the contractors as aforesaid shall be deducted from the security deposit furnished by the contractor. Should this sum also be not sufficient to cover the full amount claimed by the corporation, the contractor shall pay to the corporation on demand the remaining balance of these amounts of suffered and claimed. In event of the delay on the part of the contractor in providing the other services as mentioned in the MTF, that is labor, wayman, machine, ways, and any other services mentioned in the agreement efficiently and to move the satisfaction to the general manager and or any officer acting on this behalf, the general manager shall, without prejudice to the other rights and remedies under the agreement, have the lawful right to levy liquidated damages from the contractor at 2,000 per day or such lesser sum per day on the part of the day of the delay as the general manager in his absolute discretion may determine subject to the total liquidated damages and not exceeding 15% of the value of the contract during the operation period of the contract. The decision of the corporation in regard to the levy of the above liquidated damages shall be final and binding on the parties. The contractor shall be responsible for the safety of the goods from the time they are loaded on his trucks from the railways, goods shed or siding godown, and they have been unloaded from his trucks and godowns and any other trucks or vice versa, so as to avoid loss of grain, etc. through the holes, crevices and ducts of the trucks. He shall deliver the number of bags and weigh the food grains, fertilizer, sugar, groundnut, any other food product, etc. received by him and loaded on his trucks, and shall be liable to make good the value of the loss shortage damage during the transit. The general manager will be sole judge for determining after taking into this consideration of all the relevant
Now you are
circumstances.
saying that the Tripura High Court has considered similar matter and passed order.
My lord, that
In favor
may
of
I
the
place
FCI.
that order, my lord. That has not yet been decided. It is at hearing stage, my lord.
Yes, Mr. Barbara.
I received notice and stayed the impugned order, my lord.
Well, there are two things. Charges and demurrages. Exactly under which particular clause running bills were deducted is the subject matter of the case, both in my case, in Abhijit Paul's case, and the matter before the Supreme Court and the Honorable Judge. Let us know about what demurrage is all about, my lord. Demurrage, my lord, your lordship will kindly turn to page 72 of the paper book. Below. Free time for loading and unloading of various types of block rakes in the case of freight terminal sidings. Siding is important. Then your lordship will find in the boxes loading time 3 hours, unloading 5 hours, 3 hours. These are the time limits. This is free time. Then in the next page, the rates of demurrage charge. The word, my lord, in all these cases is demurrage. We are concerned and confined to demurrage, not damage. Suppose I am the custodian, trucks. I didn't take care of the food grains got damaged, that is different. He was relying the other clauses. Then rates of demurrage. Demurrage charge shall be levied at 150 per 8-wheel wagon per hour or part of an hour for daily detention of wagon in excess of permissible free time. Then it goes on like the 8-wheel goods wagons other than passenger vehicles irrespective. Then the rates of demurrage charge 4-wheel and 8 wheels. Then 3.42. Rates can be increased by say 2 times, 3 times or so on, and not necessarily 6 times at one go in all cases. In fact, railway may decide to levy variable rates like 2 times for the first hour, detention 3 times, like that. So beyond free time, every hour, my lord, the railway charges demurrages on FCI. Now, my lord, FCI issues consignment to me essentially 24 hours prior to arrival of rakes, which your lordship will find at page 66. He was showing about failure to produce trucks and all. Page, my lord, 66. This is the type of indent they issue. This is one copy, my lord. I crave leave to produce many other copies like this. It is issued by a divisional office Silchar. My contact is from Sal Chapra to Badarpur. Indent, allotment of wagons of rakes, so and so, freight operation. This is to inform you that as per FOIS means Freight Operation Information System, that 58 wagons likely to be arrived at Railhead Sal Chapra on 31/8. Previous day it is given. Then Badarpur High Speed Logistic is my name. 15 wagons I was allotted in the box. Below lordship come manager depot in charge FCI Ramnagar Lal Bazar requested to take appropriate measure for speedy release of the loaded trucks. It is also requested to ensure submission of all necessary correspondence documentation related to loading within the stipulated time. The road transport contractor and handling transport contractor, too, this is important, is requested to make necessary arrangements for posting of adequate man machinery, etc. so and so. And we were asked, my lord, contractors are asked to be in touch with the, my lord, said in charge and railway. Now, my lord, in every consignment, we, my lord, we give, my lord, immediately on receipt of such indent, we give our, my lord, reply like one at page 82. Page 82. To the division manager, Food Corporation, information detailing start of railway operation. That wagons will come at 22/8/22 at 8 a.m. hours at 4. Completion of transportation at so and so hours. This is in reference to above subject. Then we give the, my lord, particulars of the trucks like this. That these are the trucks we are going to place at the rail area. Then the problem is, my lord, we remain with touch. As your lordships know, normally the good trains, say here at Bamuni Mairam, the goods trains, my lord, arrive in the midnight, mostly night hours. And when, my lord, the good trains arrive, FCI being the consignee, neither the transporter nor the handling contractor can straightway receive the goods. Here, my lord, there the consignee is the FCI. When, my lord, a rake comes, FCI's personnel has to be there, railways personnel has to be there, and the transport contractor has to be there in the platform. Because seal of the wagon is first inspected and jointly by the railway and FCI personnel. Seal, it is checked. There is a ledger with the FCI depot personnel and one with the railway. Documents submitted by FCI to railway, details are entered into registers, wagons doors are open, then, my lord, unloading of wagon starts. Now, here, my lord, the job was not mine. Lordship, FCI's own admission, kindly turn to page 94. I am not the person to receive the goods at the place. You want to look? Page 94. Page 94. Yes, paragraph 18. This is FCI's affidavit.
Paragraph 18.
Yes,
That
this-
is mentioned in the order.
Yes. That with regard to statement, handling of food grains in railway siding Sal Chapra is done by handling contractor, namely somebody else. However, the petitioner is the transport contractor. Let's may keep that in mind. And then Even the handling transporter cannot receive the goods straightway. The consignor is, my lord, FCI. Now, generally, the goods train arrives, my lord, during the night hours. And now, the babus that there, the FCI clerks, they leisurely go in the next morning. That is the ground reality. And the free time is passed by that time. Suppose in the midnight, 2 o'clock, wagons arrive. And without the FCI's personnel, we cannot go there. Then what happened? Railway imposes, my lord, demurrages, counting on the hours beyond the free hours. And they simply pass on the demurrage charges to the contractors, like page, my lord. Notice. I'm sorry. 79. 79, lordship, kindly come to 79. When this happens, in a routine manner, they passes an order by like this. And it is called sanction order. Who issues it? It is the manager accounts, not the general manager contract. He gives the sanction. He is not the authority. Sanction is accorded for the payment of the following transportation bills. So and so, so and so. Manager accounts DO Silchar is requested to make payment after thoroughly checking verification bills and deduction of demurrage liability. Then your lordship will find bill period is this, gross bill amount is this. Income tax, there is no problem about income tax. Then DC, demurrage charge, 63,730. So this is issued unilaterally, without giving any opportunity to us to confront it. That is the crux of the problem. And previous page 78, my lord, in a routine manner, they give sheets like this. Amount remarks. By the time of filing, my lord, it was around 70 lakhs. And by the time the judgment was rendered by single judge, it was 2-odd crores. So unilaterally, in a routine manner, they just shift the buck on us without giving any opportunity to confront, without following any process to quantify the damage. Why it is 67,000 and why not 27,000? Nothing is done. No exercise is done. The entire damage charged by railway on FCI is simply pushed over to us. And the clause, my lord, is, therefore, clause is quoted as page 78. I will come to Abhijit's case. The clause to given page. Page 51. Page 51. It is quoted. The contractor shall be responsible for loading, unloading of the wagons within the free period. Then it says contractor shall be liable to make good any compensation, demurrage, wherefore. The word charge is not here. Charge is in different parlance altogether. Negligence, damage to, causing damage to good, etc. This is plain and simple demurrage, as per railway rules in force. Loading, unloading. Unless the delay is for reasons beyond the contractor's control. Like there is a hartal. There maybe he was pointing out to that. Strike. This clause takes care of that also. I have replied to, they gave 1 or 2 notices. not every day. And those notices, one cited by him, we replied. The question is not dispute. Question is the manner in which they imposed this demurrage. And it says the decision of the general manager in this respect shall be final and binding on the contractor. So the assistant manager in the order, my lord, has it mentioned that sanction is hereby accorded by the general manager at page 79? No. Is the assistant manager. Manager accounts far below an officer. Page 79. And on this ground alone, my lord, there is a decision of Honorable Justice Biswas while he was there.
What was the observation made in the written statement or
What's
the
it?
affidavit in opposition filed by the Railway regarding para 20 of your PPT?
Regarding para 20,
Because you said it at para 20, right?
yes. This is the provision. They didn't deny that this is not the provision.
There is a delegation of power in the MTF.
There is no, we'll
On
go
the
into
general
that.
Manager, they will act as a general manager.
Question is not that.
Delegation of
Question
power.
is the manner in which, my lord, this is being imposed, inflicts on a penalty, my lord, without following due process of law. That is the crux. And exactly on same facts, I will now take your lordship to Abhijit Paul's case, the original case, Planet Single Day. Yeah.
Mr. Barbara, just a minute.
Who knows it ever? More can I can.
Mr. Singh, before recovery of that amount, any notice was issued?
No,
Why it was-
no.
No, notice was definitely issued, my lord.
That
These
phase
are
of
the
42,
No, no, no.
143
Let us not mislead with the facts. No notice. That is the main ground.
annexure A.
No.
No.
We're asking you because 142 and 143 is the reason that where you are saying that the petitioner did not provide with the truck, right?
Yes.
Hereafter, any such notice has been issued to the petitioner
Regarding the supply of the trucks.
regarding the recovery of the
That why 67 should not, lakhs should, thousand should not be
Recovery of the
recovered?
damaged check.
No, nowhere. That is our case. What process they undertook to quantify the damage? Sir, absolutely unilaterally behind my back.
we do not have it today because what Mr. Barbara is saying that it was not done.
Not done.
And we have also not seen in your reply.
No. They cannot
Maybe
because
it
there
is
is none.
not there. But the
So if you want to
quantification,
have something from the record, you want to show us,
my lord, the annexure A to my affidavit in opposition, it starts from 105. It has been quantified, my lord, damages charges
By what procedure?
by a committee, 1, 2, 3, 4 of 4 officers, my lord.
No. Before that, before passing that order or quantifying that amount, any notice was issued.
That is not there.
So that's it.
That's what we want to know from you. Or if you have anything, you want to place anything.
So, my lord, there is a clause also, and if your lordship may kindly come to 103 of my affidavit in opposition, clause of law governing the contract and dispute resolution in case of any dispute arising out of the touching upon the contract, my lord. The GRC is a mechanism for ventilating the grievance of the contractor, my lord. So, the quantification of the damages is there is on record, my lord. The petitioner also aware of that record, my lord, and that is annexure 8 to my affidavit in opposition. So the petitioner is disputing every fact that he has supplied the trucks, that it is not quantified properly. So he is disputing though. So the burden is on him to prove his case, my lord.
Nothing
So
is in
he
dispute.
should approach the civil court, my lord,
It is the,
or he may approach the GRC, my lord.
the manner violation of my rights under Article 14, my lord.
Mr.
If
Singh,
that
Natural
notice
justice.
is that we can issue we give him another chance that these are the then what you have to say, my lord. We can issue the notice, my lord, soft notice specifically as per the annexure A, my lord. If he wants that thing, my lord.
Now, after hanging me, they want to give me opportunity.
The learned court, the learned single has taken care of it, that imposing of 9%. This thing. If we
Obvijit Pal, my
succeed-
lord, I have given.
If we succeed,
Obvijit Pal,
he will-
absolutely same ditto facts. Obvijit Pal's decision, Lordship may kindly have same fact, ditto, which this ultimately went on to Supreme Court. Paragraph 7 to 10. Obvijit Pal.
Pardon, Mr. Abhishek Singh, learned counsel appearing for the appellant FCI. And Mr. A. Barbara, learned senior counsel, assisted by
And the MS and the.
learned counsel for the respondent number 1. Anyone from railways?
No, my
No.
lord.
This writ appeal is against the judgment and order dated 8/11/2023, passed by learned single judge in WPC number 6317/2022. By which the appellant FCI was directed set aside, the learned thing will set aside all deductions made by the appellant FCI from the running bills of the writ petitioner, respondent number 1 hearing, on account of demurrage, and further directed the appellant FCI to refund the amount so deducted from the running bills of the petitioner as demurrage within 60 days from the date of receipt of the certified copy of the said order. First, by the said judgment and order dated 8/11/2023, noted above, the appellant FCI was further directed to refrain from deducting any further amount on account of demurrage from the bills of the petitioner, with the observation that the deducted amount from the bills of the petitioner, if not refunded by the FCI within said 60 days from the date of this order dated 8/11/2023, it will carry an interest at the rate of 9% per annum. as to be calculated from the date of the said order till the date it is refunded to the petitioner. Mr. Barber and its senior counsel appearing for the writ petitioner, class respondent number 1. Right, respondent number 1, let's submitted that without issuing any notice, the appellant FCI determined the amount of damages and also deducted an amount of rupees 70.
No, my lord, that by the end of the whatever is deducted is deducted.
How much amount was deducted? Pointed out in one of the annexes. 52 or something like.
It is a matter of record.
Without issuing it, deducted such a. On the other hand, Mr. B.K. Singh, learned counsel appearing for the appellant, submitted that the contract itself contains a clause. Where is that, Mr. Singh? Which page you have mentioned? 151 or something like. 57.
Page 157. Clause 10A.
No, you have also mentioned it there. Your paragraph. Your
Yes,
reply
GRC thing.
page.
No?
Just mentioned.
At page 15, laws governing the contract and dispute resolution.
50.
15, my lord. In my paragraph, I have quoted. Clause 18 within bracket B, small b.
Which page?
My lord, page 15 regarding the grievance redressal committee, my lord. It has been quoted in my paragraph, paragraph 10.
Also, that itself contains.
My lord is asking about regarding damage.
That
Grievance redressal side.
contains that any dispute arising out of and touching upon the contract At first, the same is required to be referred to the dispute of the grievance redressal committee within bracket CRC. It is constituted and functioning at the zonal office of the corporation. And if such dispute remains unsettled, then only such dispute can be settled in the court of law having competent jurisdiction. Mr. Singh, counsel appearing for the appellant FTA submitted that without complying with the provisions of the contract, the petitioner filed this writ petition, petition number such and such, wherein the Leonard Single has passed the impugn order. Issue notice returnable by 4 weeks. As such and such, land council has accepted notice on behalf of the respondent number 1 / petition. No form of petition be issued to the said petitioner shall serve. Petitioner shall take steps for subsequent notice on the respondent number 2 and 3 on or before 30th of April. With regard to the interim prayer made by the appellate, this is notice returnable by twentieth of May. Let's get on.
Observe the matter where posted on a day, my lord, and
20th of May.
posted on a day, and my lord, to endeavor to dispose of, my lord, because
We'll
these
see
are
to
not the
that.
types of cases, my lord. That
The
your lord-
matter come on 20th May, 20.
My lord, 22nd, my lord, 22, man,
You want on 22nd? Fine.
or 21.
My lord,
Whenever
efforts shall be made to dispose of at the admission stage.
that will not write. The next date, well, considering the interim prayer will make. Whatever judgments you have given, it will be.
My lord.
Mention of this item, Lordship. Mr. S.N. Tamil is out of station due to his brother-in-law accident, Lordship.
Tuesday,
Oh, Tuesday.
this bench is sitting again on Tuesday. Mr. Goswami, you will have it on Tuesday. It is submitted at the part. Counsel for the respondent present of the. He is out of station. As the brother is submitted. Sorted. To which counsel for the petition. Mr. Deepak Satya. Based on 38.
Another case is fixed on 30th. My lord, I may, my lord, mention for some little accommodation on that day, my lord. If you can-
Come on. 30th.
Yes,
Then-
yes, my lord, no problem.
Nice.